like to start by acknowledging the traditional custodians of the land, the Gadigal people of the Darug Nation, and recognise their elders, past, present, and emerging. I also like to apologise about a couple of things. One of them you already noticed is that speaking English, and some of the slides are in Arabic. So I'll try my best to use both languages to communicate the presentation. The other thing is this is not a conclusive summary of the law on violence. This is only a summarised overview of some of the theoretical and practical interactions between violence and law. This is an overview of the presentation. As I said, the beginning will be a bit of a theoretical background on the law and violence and how they interact in society. The rest of it will be more practical of how do laws actually address violence in New South Wales in a federal level and on the international law level. I'd like to begin. Jacques Derrida, the French philosopher, thinks that if we want to understand the difference between different concepts or words, then we better actually understand the power dynamics between these words. And so the first thing that I'm going to talk about is not really the beginning, it's more of the middle. And that is the relationship between law and violence in terms of socio-political theory. And that is maybe trying to, as Jacques Derrida would say, flip that power dynamic. Sorry, thank you. All right, so the first thing is, maybe intuitively you'd think that law and violence should go against each other, but in legal theory, in political theory, in sociological theory, violence is a very important instrument for law. And you can see that in the presentations earlier by Dr. Al-Umar and Dr. Paul Tabar, yes. But more specifically in a different, pathway of philosophy is the concept of monopoly of violence. That term appeared first in the essay, Politics as a Vocation. I'm reading the English part, the Arabic part, and trying to remember the original English name. That's by Max Weber, and that is where the term first appeared. And basically what it means is that in a liberal society, in a democracy, the state must have a monopoly on the legal use of violence. In other words, to enforce the laws, the state has to employ violence to subjugate and get citizens and residents to abide by the law. Of course, that idea has its roots in early liberal theory. You can see it, for example, in the Leviathan by Thomas Hobbes, and by 6 books of Republic by Jean Baudin, the French philosopher. So, going a bit more further, maybe going in sort of crossing the demarcation lines with what Dr. Tabar and Dr. Al-Umar already said, in terms of sociological theory, in structural functionalism, which I recognise that Dr. Tabar have already spoken about, so I'll be a bit brief and have my own stab in trying to explain this, and saying that, realising that maybe that's not the best expression to use given the topic. So I'll have my own try at explaining it. So in structural functionalism basically tries to explain that when societies move from primitive or Neolithical societies as hunter-gatherer societies, more towards agricultural communities and then to urbanised communities, structures appears in that society. And in these structures, you'll have groups with different interests that come from different functions, from their different functions in society. And with these different functions, you'll see that there conflicts will arise between these different classes or groups in society. And in general, violence is viewed as a method of conflict resolution. Not saying anything about its morality or ethics or its appropriateness, of course, but it's the primitive way of conflict resolution. And in that context then, law is the alternative to violence in a structured society. So if you can imagine 2 Neolithic men fighting over a dead rabbit that both of them claim that they hunted, and if you move towards an urbanised society, you'll have conflict between institutions or individuals. So one example is what the Liverpool Mayor talked about earlier today. You can imagine that if we still resolve our conflicts and issues in a similar way, then we'd expect Mr. Manon and Chris Minns from New South Wales government going in a boxing court and resolving the conflict that way, but instead they're taking it to courts. So these are the two sides that would explain law and violence in society. On one hand, law needs violence to enforce its authority. On the other hand, law tries to replace violence as means of conflict resolution. Moreover, if we wanted to look outside of the government's role or the law's role in regulating relationships and conflicts between individuals and institutions, then social contract theory comes in hand, and that's basically a similar approach, but in terms of defining how the government balances between using violence and between regulating and replacing violence. And so our social contract, our institutions, political or social or legal, are meant to balance the state's authority and power to use violence with us. And so that's the other way that role interacts with violence. And you see that with police powers, with government powers, and the conflict that arises between... Sorry. Is there? Oh, yeah. Oh, getting very... All right. So, on the larger scale then, in international law again tries to replace violence or to regulate violence when it comes to international conflict or war. That's about it for that part. Would you prefer to have the English or the Arabic? Because that slide has two different... Yes, because I'm speaking English, I'll use the Arabic one. Yeah. All right, so in New South Wales, I'm going to talk about law in different areas. The first one will be criminal law, or in Arabic, I translated it to قانون الجنائي. The main source of laws for us in New South Wales in terms of crimes and criminal law is the Crimes Act of 1900. Of course, it was made over 100 years ago, but it's been through a lot of changes and amendments and additions since then. The main part of that act that is of interest for us is the part that is called the crimes against the person. And these include crimes such as assault, or common law assault as we say it, and that's basically threats or causing someone to apprehend a threat of violence. Battery, or الاعتداء الجسدي, and any harm or injury, so bodily harm, what do we call it? Actual bodily harm and grievous bodily harm is what the Act defines. Different levels, basically, of injury to the person. Then unlawful imprisonment, الحبس غير القانوني, القتل, which includes murder and manslaughter, so it's two different levels of homicide. Then, obviously, sexual assaults and rapes. The word rape actually doesn't appear in the law, in Australian law, so it's there's a certain way that laws define sexual assaults in different levels, but basically they're one bunch of charges, basically, that the state could use to persecute perpetrators. The other way that the law deals with violence is through hate speech. In a lot of jurisdictions around the world, hate speech or hate crimes are their own category of crime. In New South Wales, that is a bit different. Most crimes, or most hate crimes, would actually be defined as a basic traditional definition of that crime and then an aggravated version of that crime, which we call the aggravated factors. So one aggravated factor, for example, for theft, let's say, is theft with a firearm or theft with a weapon. Okay? So for a lot of these crimes, if they were motivated by the perpetrator's understanding or belief of the victim's political, religious, or cultural background or opinion, then that could be upgraded, as we see in the media, into a terrorism or a hate crime, aggravated crime, basically. So it's the same crime, but with an added element of hate. Aside from these, actually, there are two different distinct charges. One called the public threat, تهديد العام, and incitement to violence, التحريض على العنف. These are two separate charges that someone can be charged by New South Wales, and these are recent changes to the law. I think in around 2 years that they've been in law. Recently as well, we've had anti-Semitism and the use of neo-Nazi or Nazi symbolism outlawed in New South Wales, and that's, I think, following only Victoria, the other jurisdiction in Australia which outlaws the use of Nazi and anti-Semitic symbolisms in public. The other way that the law interacts with violence in New South Wales is in the police powers. So as we said, the government would have a monopoly on the legal use of violence, and that usually is what you can see in the Law Enforcement Powers and Responsibilities Act of 2002. That law basically defines the powers, the police powers in New South Wales, and how they can lawfully use violence or imprison people or apprehend or arrest people in New South Wales. It of course also defines things, the defences that police officers could use if they misuse their power. So if they had, for example, a reasonable belief that they were acting in a lawful way. That's obviously a very controversial thing in Australia, and I think we've seen a lot of cases where people with disabilities or people from Aboriginal backgrounds are suffering from unlawful use of violence by police. And we've had plenty of death in custody, for example, as an example of that unlawful use of violence. So next is domestic and family violence. Again, I'm going to use the Arabic slides, but I'm going to speak in English. These are the Crimes, Domestic and Personal Violence Act of 2007 is the main legal instrument or legislation that governs that area, and it defines things such as apprehended violence orders and apprehended domestic violence orders. These are basically powers that the court could use to warn people. There's a big debate around their effectiveness actually in preventing domestic violence. In general, these orders do not outlaw anything new in the law. Instead, they just remind perpetrators that what we're doing is wrong, and that's basically why their effectiveness is debated. Generally, the difference between an AVO and a DVO is just the difference between the relationship between the perpetrator and the victim. Otherwise, the terms of the way that they, operate in law are very similar. Aside from that, there's also laws that discuss forced marriage or zawaj al-qasri and khitan al-nisa or FGM, female genital mutilation. So these laws are sort of new additions to Australian law, to New South Wales laws. They're not as new as in a few years. I think they've been added about 10 years maybe, or something like that. And they relate to international laws around modern slavery. Finally, the most recent changes to this area of law is the Crimes Legislation Amendment Coercive Control Act of 2022. These laws were approved by Parliament about 2 years ago, but they actually just entered, what do they call it? Criminalisation. They've only become crimes now. So they were approved 2 years ago, but they're what we call ascension to become actually applied law this month. So about 3 weeks ago, I'd say. July, 1st of July this year is where they became effective in New South Wales. Coercive control the changes came about from some recent inquiries into domestic violence and victims who, suffered death at the hands of husbands or fathers. And part of the recommendations in these inquiries was that there's an earlier indicator, a very good indicator of the eventual tragedy that is coercive control. Coercive control generally means when the perpetrator uses their power, their authority that is entrusted by them by social norms or by their status as a carer or as a provider in a family or in a disability towards a person with a disability, and they use it to control or monitor the movement and the financial or other resources in the family or in the relationship or their relationship with others. So I'm going to say these in Arabic because I think these new changes in law needs to be communicated more to Arabic speaking communities. التحكم القسري اللي هو يشمل من يعني شو نقول بالعربي among other things من بين أشياء أخرى يشمل المراقبة أو التحكم في موارد الضحية المالية أو غيرها. أيضا يشمل المراقبة والتحكم في تحركات الضحية أو في علاقات الضحية ببقية الأشخاص سواء الصداقات أو العائلة. هذه القوانين دخلت حيز التنفيذ في نيو ساوث ويلز في الأول من يوليو 2024 بمعنى قبل حوالي 3 أسابيع. Next, we've got child protection laws. They're mainly governed by these two instruments, so Children and Young Persons Care and Protection Act 1998, which basically defines... sorry?
I was just saying it's not that old, is it?
It's not that old, considering the Crimes Act is 100 years ago, yeah. I think we've had forms of child protection before, but they were not the best. They gave us things like stolen generations, for example. So the 1998 Act basically it tries to protect children in the care of their families. And part of that, obviously, is instilling a guardian for children in New South Wales who's basically responsible of ensuring that children in New South Wales are treated well by the families, and the alternatives take away these children and place them with other families or in the care of government institutions. The other instrument is Child Protection Working with Children Act. I think a lot of you would be familiar with that act, as I guess a lot of you would also hold a Working with the Children check. It's not a license, I don't know what to call it, it's just a check. Yeah. So basically in these two acts, the types of... It's accreditation, yeah, but I'm not sure if license is the right...
It's a registration.
Yeah. Anyway, in all cases, just to... How much time have we got?
2 minutes. 2 minutes.
All right, okay. So the types of violence that these acts define include physical violence and abuse, sexual violence and abuse, and emotional violence and abuse. In Arabic, these are العنف والإساءة الجسدية, العنف والاستغلال الجنسي, العنف والإساءة النفسية والإهمال, or neglect. Neglect basically means it doesn't include things like not buying a child a PlayStation, but it includes their necessities to live and to access their child's rights, including education, entertainment, relationships, and all of this. Obviously, the parents would still have some form of control over what their children can access, but they cannot deny them access to essential needs. All right, and victim support. I'm going to have this in Arabic again because it's very important. Part of, I guess, your interaction with law as non-criminals would be as witnesses, as victims, or you might have someone in your family who's suffered from this. So this is very important information. In New South Wales, victims can access some services and support from government, including financial support or compensation and counselling and mental health services. So these are accessed through different means. There are different criteria depending on what type of crime you were the victim or witness of. And the support can also extend to families of victims and first-hand witnesses of say, a crime scene, for example. Aside from this, there's also specialist victim support services and the National Redress Scheme. The National Redress Scheme is specifically a response to institutional child sexual abuse, historical cases. So that came about, I'd say, 10 or 11 years ago as a response to the Royal Commission that inquired institutional child sexual abuse. Aside from this, you'd also might need to remember that there are different ways to report crimes, including by going straight to police and creating a police report, which in Arabic would be 1 minute, 2 minutes?
No, we're done. Just
1 minute, okay. All right, let's move on very quickly then. In federal law, it follows a very similar structure to how laws work in New South Wales and other states. The only difference is that sort of cares about more important or bigger macro sort of issues, including hate crimes, counter-terrorism, and violations of international law, such as crimes against humanity. These are mainly governed by the Crimes Act of 1914 at the Commonwealth level and Anti-Terrorism Act of 2005, number 2. Right. Finally, at international law, this is a bit of, don't really have time to explain it all, but basically there are two different types of agreements at international law. There are agreements that affect the local laws, and there are agreements that affect relationships and conduct between states. So that's what we call humanitarian international law side. These are things like the 4 Geneva Conventions, the 2 The Hague Conventions, and these basically, as I said, affect their conduct in terms of war, dealing with refugees, civilians, and medical staffers. On the other side, these are the things that would affect human rights, women's rights, children's rights, things like this. The reason I mention them is that, as earlier presenters mentioned, taking away the rights of people is a form of violence, and especially when it comes to groups or individuals that cannot otherwise access these rights, like children, women, Indigenous people, minorities, or they're political or religious. That's the conclusion.